Hello everyone, I'm Dr. Kalpana. In this lecture, we would try to understand when an agreement is enforceable by law is contract and testing its legal validity under Part 1 and 2, which are the valid agreement in under Section 10 and which are void under Section 23. Then it comes to performing a contract, or interchangeably it is called discharge of contract. In case of breach of contract, what are the remedy? In this lecture, we would be dealing with two topics. So performance of a contract means fulfilling the obligations agreed upon, marking the natural end of every valid contract. This presentation will explore the various aspects of contract performance, including relevant legal provisions, different modes of performance and consequences, and remedies for breach of contract under Indian Contract Act. So relevant provisions and mode of performance. Indian Contract Act 1872, Section 37, obligation of the parties to the contract, whatever the terms, conditions agreed upon. But parties are under obligation as per Section 37. Section 38 to 39, offer of performance and refusal, is dealt under Section 38 and 39 subsequently. Section 40 to 45, performance by parties, joint promises. Section 46 to 67, time, place, manner of performance. Mode of performance are of two types. Actual performance, both parties fulfill obligations discharging the contract the way it was agreed upon. Attempted, offer of performance, that is called tender. If one party offer performance and other refuses, offerer is not liable for non-performance. That is dealt under Section 38. Breach of contract is something, a breach of contract occurs when one party fails to perform as per contractual term. Actual breach means failure to perform when performance is due. Anticipatory breach, when a party refuses to perform even before performance is due, that is provided under Section 39. In cases of anticipatory breach, the promisee can either treat the contract as repudiated or sue immediately or wait until performance date. A notable case is Frost versus Knight, where promise for future marriage was breached, allowing immediate action. So now coming to the what are the remedies for breach of contract? Ordinary damages. As I want to tell you something, when it comes to damages for breach of contract is concerned, these are called liquidated damages. Liquidated means fixed damages. Whatever the loss has been occurred, that is very clear to the parties. So compensation for direct loss from the breach is provided under Section 73 to 75. Consequential or special damages awarded only if communicated and foreseeable. Headley versus Baxendale is the case, which is a landmark judgment where, because of breach of contract, there might be loss, a lot of loss, which is recurring loss. So special damages can be awarded because of that breach. Nominal damages award when no actual loss is shown. Punitive or exemplary damages, rare in India, limited to tort like contracts, for example, breach of promise to marry. In India, Indian law, such as McLeish-Sethi versus Coffee Board, emphasizes compensation for naturally arising losses. The forcibility test was further clarified in Kofus versus Zanico Limited. Liquidated damages versus penalty, a pre-estimated amount of loss agreed upon by the party in the contract, that is called liquidated damages, which is called fixed damages. So Indian law under Section 74, there is no need to prove actual loss if amount is reasonable. However, court may reduce the amount if it deems it is excessive. Penalty, then amount intended to deter breach. often disproportionate to the actual loss. Penalties are usually not fully enforceable by the court. Landmark cases like Fateh Chand versus Bal Kishan Das, ONGC versus Saw Pipes clearly clarify that damages must be reasonable and courts can reduce even agreed sums. Now, coming to what are other remedies, court can ask for specific performance or injunction. Specific performance means here when damages are inadequate, court may enforce actual performance of the contract under Specific Relief Act 1963. This remedy is discretionary and requires a valid contract where damages are insufficient. Not enforceable if personal skill is involved, for example, employment contract, continuous supervision is needed, like case KM Kamath versus KR Baliga and company highlights the discretionary nature of this remedy provided by with the courts. Injunction when breach is threatened and cannot be compensated by damages, court may restrain a party from acting. An example is restraining an employee from joining a competitor during a valid non-complete compete clause subject to Section 27 of Indian Contract Act. Time as the essence of contract and quasi-contracts. So time as essence under Section 55, time is essential when expressly stated or implied in the contract. Delay can lead to breach and recession. However, as seen in Hind construction contractors versus state of Maharashtra, time is not always the essence unless specified. Quasi contracts are dealt under Section 68 to 72, establish legal obligation even without a formal contract. These arise from situations like payment for mistake, unjust enrichment, ensuring fairness where a formal agreement is absent. Now, coming to the summary of remedies, ordinary damages are provided under Section 73 for direct loss. Special damages are provided again under Section 73, must be foreseeable. Liquidated damages, Section 74, enforced if reasonable. Specific performance, specific relief act, discretionary when damages are inadequate. Injunction is again provided under Specific Relief Act to prevent breach. Anticipatory breach is provided under Section 39, action before performance is due. Restitution is provided under Section 75, compensation for rescinded contract. With this I would end here. Happy learning.